Okay, Mr. Zanini.
Morning.
Morning, may it please the Court. John Zanini for the Commonwealth. As the Court is aware, we're seeking to have a suppression order entered in the Dorchester Juvenile Court, vacated and reversed, and have the case remanded for trial. Just to refresh you on the facts, a juvenile entered the courthouse in Dorchester. The judge specifically found there were 2 signs posted at the door that state all bags are subject to search. The juvenile placed his backpack on the table next to the x-ray machine and walked through the metal detector. An court officer then informed him that the bag would be searched. The juvenile then went back through the metal detector, took his bag, and went outside to the courthouse steps. A police officer then went outside and said to the juvenile, "Come here." The juvenile then ran, and he was chased by multiple police officers, ultimately apprehended a few blocks away. The officer who caught him said, "Why are you running?" because he wasn't personally aware. The juvenile said, "Because of the bag." The officer opened it and looked in, and there's marijuana in the bag.
At what point do you say consent was given?
Well, I think that consent is an interesting issue. It certainly, if consent is in play at all, it's at the courthouse when he went in and set his bag down and walked through the metal detector.
But how far do you have to go? Do you have to walk through the metal detector to give consent? Do you have to simply walk into the courthouse door? Is consent given at that point?
Luckily for me, you don't have to decide whether it's the courthouse door today, where the signs are posted. But
He actually put his bag down on the conveyor belt or whatever it is, didn't he?
Well, the judge didn't actually find it was on the conveyor belt. She found it was on a table next to the x-ray machine, I believe, in the judge's findings.
Okay, well,
so
that's
it's not
probably
quite on the conveyor belt. But she went out and took a view, and of course this court could also take a view if it wanted to see exactly what the judge saw. But when you walk in at Dorchester, on the left is the x-ray machine and the table. Really it's just one continuous. It's not like a separate table somewhere removed from the x-ray machine.
So he gave up possession of it.
He did. He let go of it, put it down, let go of it, and walked through the metal detector.
And at that point, at the point that he put his pack down, do you take the position that that's when he gave consent to the search of the pack?
I would say he either consented, if you want to call it a consent case, or at a minimum he submitted to the administrative search. And so even if you look at it as less than a full voluntary consent search, he still submitted to the authority of the government to conduct the search to keep the courthouse safe and secure at that point. And I think that the question then is whether, once you submit to the authority of the government to conduct the search, can you sort of pretermit the search and say, well, I've decided today I'm not going to let you complete your search in order to keep the courthouse safe?
Do you assume that he read the sign and comprehended the signs and comprehended what they said?
I do.
So if you had someone who didn't speak English and there was a sign in English that said, we're going to examine your possessions, and they put their pack down, not understanding what the sign meant, no consent?
Well, I think you have an evidentiary burden there where you've got to provide sufficient facts to show that they were there watching other people go through the process and seeing nobody get into the courthouse without going through the process unless they showed some form of official identification. So I think there you would just...
Well, of course, in this day and age, most people would be expected, no matter whether they spoke English or not, to understand that in certain government buildings, and airports and so forth, one has to go through these kinds of searches.
It's pretty commonplace.
Common knowledge.
Yeah, the JFK building across the plaza is, you can't get in there without submitting to a similar search. I mean, many government facilities. So I think people are generally familiar with the idea.
Let's take a step back a little bit. So he terminates the search or the administrative search process, gets his bag back, and begins to walk out of the courthouse, or at least goes out onto the courthouse steps. Is there reasonable suspicion at that basis for the police to stop him
Right. I think there is reasonable suspicion at that point in time, because the only reason to, after you get through the metal detector and an officer says to you, now we're going to look in your bag, the only reason to avoid the search is because of criminal conduct.
Well, didn't he say he did not want the bag searched?
I believe,
Isn't that a finding, which is a further indication that perhaps there's something in there that...
yes, the juvenile said,
I
according
don't
to
want my bag searched.
right, according to the judge's findings, I don't want anyone to search the bag. So
I mean, suppose they had a machine gun in there and just went out into this, the front of the courthouse, opened up the bag and started mowing everybody down.
right.
Well, but let's assume for a moment that he simply approached the machine, and he was then instructed, put your bag here, we're going to search it. And he said, I don't think I'm going into the courthouse today, and turned. Same reasonable suspicion at that basis, right?
I don't think so. Under the facts of this case, he actually does put the bag down, get through the metal detector, and then not only has he read the sign, but then the officer says to him, we're going to search your bag. So I think here it's not just making it across the threshold and changing your mind. It's quite a bit more conduct.
But I'm talking about how that bears on reason. Maybe you're answering the question, but how that bears on reasonable suspicion. Is there a difference somehow if he started the process? I understand that if he started the search process, you may say as an administrative matter, the police have a right to complete it. But just in terms of reasonable suspicion to believe that he is armed or is about to commit a crime. The fact that he started the process, then backed off, different than if he got literally there to the sign, read the sign, and said, I think I'm going away. And the officer said, well, excuse me, come over here. What do you mean?
Well, I think it is different for reasonable suspicion purposes, because in our case you have more facts than someone merely getting to the courthouse door, for instance, and reading the sign on the exterior of the courthouse and then deciding to go back down the steps and walk away.
Or if he gets in because he can't read the sign, doesn't see it, and sees people going through and having their bag searched and decides at that point he's going to leave.
Right, and it's very fact-specific. Some people may see an officer removing, I don't know, a penknife from someone's bag, and they may realize, I have a penknife in my bag, and walk out to put it back in their car. So that may not be enough to get you to reasonable suspicion. That in and of itself, this sort of a bare minimum fact there, may not get you there.
But you do take the position, if I understand you correctly, that you don't even need to get to reasonable suspicion because he had already submitted to an administrative search.
That's correct. And the administrative search is to keep the courthouse safe. It's not to catch him in possession of a weapon or contraband. It's to make sure the courthouse is safe, and it's to deter not only that individual, but anyone who might enter the courthouse from trying to bring in a weapon. And because it's to deter any and everyone, you can't have somebody or a variety of people who try on different days and see if they're going to be able to sort of get by without the bag search. And if they're not going to make it through, turn around and walk out on any given day.
But I just want to make sure that I know this is fact specific. I couldn't agree with you more. But what you're saying is the reason this case is different from simply entering and going up to the machine and saying, I don't think I'm seeing the sign, seeing that they're searching, and leaving before literally surrendering the bag, and the fact that here he surrendered the bag and went through the magnometer or whatever it was, that there's a difference between those things, yes?
There is a difference, but the judge's findings also found there's a sign on the courthouse door. There's 2 signs posted at the door. So I think that if you get to the threshold and you read the sign at the threshold and you turn around and walk away, that's not reasonable suspicion, I don't think, and you haven't submitted to the administrative search.
But if you get near the
But
machine,
if you
you
cross
have?
the threshold, now maybe there's a reason to believe, well, you already saw the sign, you've already crossed the threshold.
You may or may not have seen the sign. I mean, you're walking into the courthouse, you're talking with people. There's a reason why there's signs at several places, but now you're actually going to have to submit to the search.
Right.
Isn't it?
And maybe you took the chance, hey, maybe I won't have to submit to the search today. Maybe somebody's asleep at their station. Maybe I'll be able to walk around the machine. So in those circumstances, could you say, well, maybe it's not probable cause, but is it reasonable suspicion? Are there objective facts to indicate maybe that person's trying to smuggle a weapon in?
So it'd be reasonable
That could be
suspicion to
enough.
do what?
To at
Ask the
least,
question, where are you going? Why aren't you going through the machine? Or reasonable suspicion to take the bag and search it?
Well, I think you can ask anybody in the world, where are you going, what are you doing, why are you walking away? That's not a seizure.
Or
So-
stop, come here. I want to ask. I mean, that's what's going on here. He was asked to please stop, come here, and then he sprinted, right?
Right, which, and I would note that although in our brief we conceded come here would be a command, you don't have to find that that was a seizure. There's the Barrows case, which I think is in 436 Mass. There's the Stout case, where there's at least two commands given. Not quite commands, but generally, some of these cases have the police saying more than one line to someone. Can I talk to you? Can I speak with you? Hold up a sec. And then if the person continues on their way, there's a second, more authoritative command where this court has said, well, that second one is certainly the moment of seizure.
Certainly the chase, at the moment of the chase, there's a seizure.
Sure, but just saying to somebody, hey, you, come here.
I understand.
May not be the moment of seizure. If that's not the moment of seizure, then you can also factor in the flight down the courthouse steps and through the neighborhood.
Could I ask you about a later point in the scenario when the bag is itself ultimately searched? Arguments are raised by the juvenile that the bag should have been pat-frisked, if you will, before being opened and searched. What is your response to that?
Well, I think that if the administrative search, in fact, was not sort of limited geographically to the actual locus of the entrance of the courthouse, but if the administrative search, if the idea is, gee, once you submit it to the administrative search, the fact that we had to complete it a block away doesn't matter. It's still part of the administrative search to deter people
Well,
from
of course, we're
smuggling weapons.
focusing here on weapons, but it could also, as it did here, contain drugs, because oftentimes there are efforts to smuggle drugs into courthouses to get them to prisoners, and, and a pet frisk might not disclose it.
Right, just
Drugs.
feeling the exterior of the bag might not disclose a crime being committed, so, and when he says because of what's in the bag, evincing some consciousness that
Is the
there's something
size of this
illicit in
bag
the bag.
described? I assume it is. It's a backpack,
not-
I know, of some sort, but
There's no factual finding describing the size of the
okay.
bag, so, right, there's
mean-
no finding to eliminate the
I
possibility.
mean, handguns can be small, and depending on what's in the
Right.
bag, you might not
Right. A
even
small
feel it's
Derringer,
there.
a small Derringer could be inside the bag, inside a piece of clothing. and
Could be a
you couldn't
knife.
possibly find it.
Could be a knife.
A knife, brass knuckles, any number of small
Nunchucks.
weapons.
I mean, you just look at what they collect at the doors coming into these courthouses. It's a,
Right. I don't think we've gotten to the point of
Arsenal.
searching for shampoo bottles at the courthouse doorsteps yet, but
What's the interest in
airports are
food?
at that level. What if it was food? I
Yeah,
mean,
that was one of the items of contraband, that they wanted to keep food out. Why keep, I don't understand that.
I don't know, but I generally
coli.
don't, bring
Well,
food into a courtroom to have my meal in the courtroom. But the point of the search, though, is as long as the search is not directed at sort of licit items, as long as the search is directed at weapons and deterring smuggling weapons,
Could have been
the fact that the scope is a little broader, I don't think invalidates the search.
could have been a small bomb.
Well, but the point is the first point, and it's a point raised in the other brief. I don't know whether we have to decide it, but is that the search policy of the court is simply too broad. You're going to have this administrative search to look for guns, to look for drugs, to look for food, because the court apparently doesn't want food to be brought into the courthouse, or to look for other contraband. And I guess the first question, is that policy simply too broad to justify this sort of routine searching of everyone who comes into the courthouse? Do you think it is?
Do I think the policy is too broad? No, because I think that the court does have the right to control whether or not you bring food into the courthouse.
So the court could have a policy, we'll have a machine here, everybody's bag is subject to search, not reasonable cause-based search. And oh, by the way, people often have to come into courthouses, right?
There's no evidence on the record this individual had to enter the court.
We're going to search everyone's bags for food before they can come in. Do you think that would pass muster under the United States Constitution?
Well, I think it's a question of whether the court can control what people can bring into the public courthouse. And I know that the court
Or when can people
regularly-
be subjected to these kinds of searches? What kind of urgency, what kind of what kind of, because what we're talking about here is a warrantless search. We're talking something that is per se unconstitutional unless there's some fairly significant justification.
Sure, if a search of a person warrantless needs to be justified.
Well,
There's
it
no
certainly is
question about that.
justified by the need to search for weapons,
Right, the fact that the...
and probably also for drugs. And once that's going on, you might as well nab the candy bars as well.
Why not? Well,
Well, if the policy is valid, then it doesn't matter that the officer interpreted it in a slightly broader scope.
Okay.
I just want to conclude, I was remiss in not introducing Mr. Donald LaRoche, who's an assistant district attorney who handled the case below in Dorchester District Court, and I would otherwise submit on the brief.
thank you. Mr. Poole?
Good morning. May it please the Court, my name is David Poole, and I represent the juvenile defendant in this matter. And I'd like to start, if I may, with where the Court ended speaking to Mr. Zanini, and that is with respect to the search policy in effect at the Dorchester Court at the time of this screening procedure search. Under this Court's holding in Commonwealth versus Kharkov, other cases as well, virtually every federal court and state court, which has considered the question, has consistently, including this court in Kharkov, obviously, has consistently held that in order to justify a suspicionless administrative search such as this one, in other words, law enforcement officer has carte blanche to go through somebody's effects without any individualized suspicion. In order to justify that, the purpose of the administrative search is a narrow, limited one, and that's to prevent persons from bringing weapons and other similarly dangerous items into the building.
Or drugs?
Respectfully, Your Honor, no. That in this Court's finding in, or excuse me, decision in Commonwealth versus Harris and in Commonwealth versus Kharkov, both make it clear, and the federal cases from the 1970s and 80s that are airport search cases make it clear that the purpose may not be a search for evidence of crime.
But that's not what it is. They want to make sure that drugs don't get into the hands of somebody that's in custody in the courthouse.
It's a very different situation entering a courthouse than entering an airport or the geographical area in Cardiff. Because in a courthouse, drugs can be dangerous because they can be given to the people already in custody. And that's probably the reason that they're being brought in, if they are.
I'm sorry. Absolutely, Your Honor. Although in Commonwealth versus Harris, Your Honor, that is a courthouse search, actually the Suffolk County Courthouse right next door. And again, the court in that case adopts the same standard as is universally adopted in my understanding, and that is restricting the purpose of such a search to excluding weapons and other dangerous things like that from the courthouse or from any other building. I agree completely that it's a courthouse stands in a different footing, if you will, from an airport or some other kind of facility. But the standard, I'd suggest, is absolutely the same.
Well, can a jail search people entering to keep drugs out of the jail?
Absolutely, Your Honor.
And that's so that the inmates don't get the drugs.
Absolutely.
Doesn't the same reasoning apply here in the courthouse?
Well, I'd suggest that the administrative search with respect to a jail, Your Honor, is of a type entirely different. In fact, jails and prisons with very little cause ultimately can strip search, if necessary, an entrant. That is not the sort of facility that a courthouse is, an airport is. Very sensitive buildings, facilities, subject to all kinds of dangers. However, they're also, Your Honor, subject to people coming and going every day. They're publicly available. They're public facilities. Mr. Zanini pointed out that there's no evidence that the juvenile had to be in the courthouse that day. However, I'd suggest that, in fact, the burden it goes the other way. That is, it's a public building. There's no evidence in the record to suggest he was just wandering in there to bring marijuana into the courthouse. And, in fact, I'd suggest that courthouses stand in very different stead from jails and other facilities like that. The other point, I think, is worth considering with respect to this is, again, this is a suspicionless search of everybody coming into the courthouse, with one of the objects being determining whether somebody has a sandwich. And I don't say that lightly. I bring that up because it points up the extreme overbreadth of the purposes of this.
What's the rationale behind keeping out food?
I can't tell the court. I can speculate that it's court cleanliness.
That's
I really
exactly
don't know.
what it is. And it's been a problem in many courthouses, especially the older ones like the Dorchester Court. I don't know if that's part of the record, though.
It's not, Your Honor. The record is, and just to be clear, the record is not, and this is not a case where the officer is searching for weapons under a proper, narrowly drawn search policy, searching for weapons, and he inadvertently comes upon contraband or food.
Why do we have to worry about food anyway? I mean, if they find food, nobody's going to get arrested for having food. They'll just say take it out or leave it outside. They didn't find food here, so why are we going to worry about food?
Well, Your Honor, the fact that that's one of the purposes of this suspicionless search policy invalidates it as an administrative search. That is,
Was that argued below as one of the reasons?
I believe so, Your Honor. I did not represent the juvenile at the trial court level. However, it's my understanding, based on the judge's findings and certainly based on the memorandums submitted to the single justice with respect to the Commonwealth's application for interlocutory review. I would also point out, Your Honor, that the Commonwealth has framed this as an administrative search case. And based on that framing, I'm arguing that the administrative search is simply invalid.
Well, if for some reason food were not a legitimate subject of administrative search, that doesn't invalidate the policy for looking for weapons or drugs, does it?
It certainly does in this instance, Your Honor.
It invalidates the whole administrative search policy here.
It does.
Why?
Well, because essentially, Your Honor, the policy is overbroad in its purposes. In this case, by the way, that invalid policy, the Commonwealth seeks to bootstrap that invalid policy into reasonable suspicion out on the courthouse steps to stop the juvenile. But to get back to the court's question, again, what we're talking about, Your Honor, is a doctrine, that is the doctrine of administrative searches, that is very narrowly tailored and requires both every reasonable means to reduce the intrusiveness and still accomplish a legitimate goal, legitimate administrative goal, and also that the goal be legitimate. And the court's analysis in Commonwealth v. Kharkov, which on the facts is a different case, but the court makes clear in its opinion that analysis applies to every administrative search. In other words, that's the Article 14 analysis for administrative search.
How do you say the court, how should a court proceed if it wants to check for weapons and perhaps drugs, and let's even include food if they have a policy of trying to discourage people from leaving food in the courtrooms that will attract vermin and that kind of stuff? What should they do?
Well, with respect to food, Your Honor, it's harder for me to imagine a practical way to keep drugs out besides enforcement. But as a practical matter, in terms of food, certainly there are court officers in every courthouse. There are other staff people in every courthouse, and essentially there are signs up in every courthouse barring or prohibiting food. Now that means that if somebody has food, they either have to throw it out or leave the courthouse. But what it doesn't mean, Your Honor, as a matter of an administrative search, constitutional policy, is that a court officer may dig through someone's personal belongings in order to see if he or she has a sandwich. And I think it's important to consider, Your Honors, and I think it's easy to think of examples in which a person could come into the courthouse and not want his or her personal possessions rifled through by a security officer
at a public entrance to what is a busy courthouse. And by the way, the facts are the findings are somewhat unclear, but I'd suggest they suggest very strongly that what the security officer was proposing to do was not put the bag through the X-ray machine, but in fact to search it manually.
Yeah,
In
but
fact-
I want you to answer my question. So we want to keep weapons out of courthouses. We want to keep drugs out of courthouses. And assume for a moment there's a valid reason to discourage the food. How should a court do that?
I'm sorry, Your Honor. I thought I had, pardon me. I think the only constitutional means that occurs to me that a court may do that is simply to enforce the policy within the courthouse. That is, make it clear outside the courthouse that food is not allowed. And if somebody is seen with food in the courthouse, make them either throw it out or leave the courthouse.
So an officer is searching for the weapons or the drugs and comes upon the sandwich, which he knows the person shouldn't be bringing into the courthouse. Can't he, having come across the sandwich, do something about it?
Absolutely, Your Honor, and I didn't mean to suggest otherwise.
And it seems to me that seems to be what this officer, is implying by his answer, that those are the things he's looking for, i.e., those are the things he will do something about if he finds them. Weapons, drugs, food. Not necessarily that the notion that we have all of this security up just to keep food out, we know that's not true. A metal detector won't find food. The primary purpose clearly is weapons. Can't it have this tag along? Since we're looking, we might as well enforce our policy against food at the same time.
Well, Your Honor, I'd answer your question yes, and then if I may back up, and then I'll go back to it. The record evidence in this case, Your Honor, is that the courthouse screening policy is to search for weapons and other contraband, including not limited to food, drugs, and other contraband. And further, there's no evidence whatsoever of prioritizing among those different items. Now, obviously, commonsensically, it's quite easy to do. But the record is not that, Your Honor. The record is searching for all those things on an equal footing and searching for all those things, all those items, excuse me. And obviously, this is a case involving a warrantless search, and it's a case where the Commonwealth bore the burden of establishing facts that from which the judge could make certain findings, from which obviously this court could then proceed legally. And the Commonwealth didn't do so, Your Honor.
Let's go to one of the strongest arguments that the Commonwealth has, and that is that your client subjected himself to this administrative search, not only came into the courthouse, went through the metal detector, put his bag on the table, at which point it would be checked one way or the other, and then decided to back off and not let the search be complete. Isn't that your big problem here on the facts of this case?
I don't think it is, Your Honor, and this is why. At the point that the juvenile put his bag down on the table by the X-ray machine, went successfully through the metal detector, at that point, the security officer told him, I'm going to search your bag. In other words, I'd suggest that those signs outside at the door are notice of what we all expect the protocol to be. In other words, a bag goes through the X-ray machine. If there's something suspicious or unidentifiable, then somebody might follow up with a hand search.
But is it constitutionally required that the bag go through an X-ray machine before it gets opened and just physically examined?
Well, what is constitutionally required is that the means of achieving the legitimate goal be the least intrusive as possible. And again, the court discussed that in Kharkov. But, Your Honor, at the point that the juvenile was told by the security officer, I'm going to search your bag, that's notice. The officer is giving him...
Why isn't the sign notice? Because the sign could mean that every bag is subject to search. I mean, if I saw that sign, I would assume that my bag was going to be searched.
Certainly, Your Honor. I suggest to the court that given what any visitor would see walking into the courthouse, that is an X-ray machine sitting there, a metal detector, given what we all expect the protocol, if you will, to be, in other words, bag goes through metal or X-ray machine.
I don't see why you say that. I don't see why anybody coming in would expect that a sign that says your bag is subject to search would expect that that means only metal detector search and doesn't mean hand search. I would expect that, given today's situation, that I would hope that all bags are searched.
But then at the point, Your Honor, that the security officer tells the juvenile directly, I'm going to search your bag, and gives him notice and gives him an opportunity to make a decision. That's just not, I'd suggest to the court, it's just not mere words. In other words, the security officer tells him that is your choice. I'm going to search your bag or do what anybody's entitled to do under an administrative search, which is decline and leave the courthouse. He declined and left the courthouse. And furthermore, I would point out that the judge took a view, having seen the security area, having heard the testimony about what the juvenile did there, she specifically did not find that he had agreed to a search of his bag before leaving the courthouse. In fact, just the opposite.
Maybe that's an unwarranted finding, given the existence of the signs.
Well, the question is whether he has to agree to anything once he's started the search protocols, once he's submitted to the administrative search. The question is whether he really has, at that point, any right to say, no, I've decided, stop the searching, don't search this bag, this pocket. But let's assume for a moment that he has, in fact, given himself to this search process. And the Commonwealth does have the right to complete the search. What does that mean when he takes his bag and runs? Can they then search it where they find him, or do they I mean, what is it? What happens now?
Well, Your Honor, first of all, he doesn't run. He walks. There's no evidence at all that he does anything except leave in a perfectly measured, normal way out of the courthouse.
Until he was asked to come here.
Certainly. And I suggest very strongly under Barrows that is a seizure. He had ended his contact with law enforcement, didn't go into the courthouse, leaves, police officer pursues him. But at any rate, at the point he is later stopped by the two officers, handcuffed, and his bag is out of his possession. As I explained in more detail in my brief, obviously, I'd suggest that the police do not have the right to go into that bag.
But if they had the right to go into it, if he had submitted to the administrative search and they had the right to complete the search, clearly they could have completed it after they caught him, even though it was outside of the courthouse, correct?
Yes, Your Honor. I'm sorry. I misunderstood. But the bottom line on that, Your Honor, is the administrative search ended when he left.
I think
when he left the
your
courthouse.
time is up. Thank
Oh,
you.
pardon me. Just in closing, I would ask the Court to affirm the finding of the juvenile court for all the reasons cited in my brief. Thank you.